Are you proceeding with sentencing? Anything you wish to say on behalf of your client? All right, so here's my question. What do you do?
I check on the quality control for Amigos Cantu.
And who is, Ms. Correa to you?
Yeah.
Yes, the person who's in the vehicle with you, the adult. Jeanette?
Zero.
Correa?
Oh yeah, that was my girl.
Was.
Yeah.
And the 8-year-old who was in the vehicle, was that your son?
This one.
And so where is his mom?
That's
Oh, she's your girlfriend,
Yeah.
but she's your ex-girlfriend.
yeah.
So has Child Protective Services been involved in your life? So do you live by yourself or with someone?
That was my mom.
Are there any children in the household?
No.
All right, this is what the court will do. There's $1,000 fine, that will be probated. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 40 days. There's to be no employment as a home health care provider or with minors. Field visits 1 time per month until further notice. 3 years deferred education. 200 hours of community service restitution. I'm gonna order parenting classes. Once that's completed, the community service hours will be deemed satisfied. TAP evaluation out of custody. If you miss that TAP evaluation, a motion to remove is gonna be. How often have you been using?
It was very safe.
Here's the thing, now's the time to tell me the truth, because I'm trying to set conditions that will mean that you'll be successful.
Like a year or two.
I'm sorry, what?
A year or two.
No. How often have you been using?
Or
Okay,
like
so-
baby, like.
Yes.
Yeah, baby.
All right, there's gonna be sober support meetings, 90 and 90 days. And the life skills course. Probation, is there anything else?
No, Judge.
Is there anything else you need in order to be successful?
No.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. In this court, communication is key. If there's an issue, you need to let probation know about it. If you feel that they are not addressing it, you can always come back to the court and address it with them. All right, good luck to you.
I appreciate it.
All right, thank you.
Thank you, Judge.
You're welcome. Norma, on page 2, what's the date for Luna?
Also, yes.
All right,
Stay strong.
let's do it in 2 weeks. And if she's accepted, we'll be able to take her off docket. All right. All right, anyone else ready?
I can't talk to right now because I'm waiting, but, oh, mic up there.
Venable owes me $20 and a carton and a case, a pack of cigarettes.
I'll pay for you.
I was gonna say, it falls to you now.
You remind me every time. Rules, that's about $30, right?
All right, just give me one moment.
Can you go put the mic up there? Erica.
Something's going on. I don't know what there's that.
Overhearing what's being said over there. If you want, you can be brought back this afternoon.
They brought the wrong Eric Cantu.
But everybody has a different. If you want to advise them, that's fine.
I don't oppose them in,
Is the state opposed to that?
as far as, yeah, just for the bond, that's easier for everyone.
All right, if you talk to, Jeffrey and Ms. Ferguson.
Okay, yes.
The state. So, yes, it's gonna be by Zoom.
Okay.
They brought the wrong Eric. Yeah, they just built.
He's already been right down.
Oh, okay.
He's coming? Okay.
Oh, he's coming.
Well, he's coming.
Oh, he's being brought over,
He's
okay.
being brought on. He's in the transit.
Will you just text me when he's here and I'll come right back? Okay.
All right, who's next?
Danny, page 3, 4 down.
Denny Rivas. All right, he's scheduled for a jury trial on, I have him down as a jury trial for January 25th. Why is he here?
That's a Sunday. I think you meant the 15th,
Oh, okay.
and you put 2/5.
Oh, yeah, I see the correction in the system. So,
Yes, Your Honor.
All right, counsel, have you received all discovery? Did you review it with your client?
Yes, Your
Court will find that the state is in compliance with discovery. Mr. Hernandez, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, so that's to waive the habitual offender enhancement allegation.
Any objection?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with possession of a controlled substance penalty for a blunt less than 1 gram in a drug-free zone. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea, it gives you more than you bargained for. The fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call it the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Correct, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he does.
Mr. Hernandez, has anyone threatened, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count 1, waiving the enhancement. They're asking that your punishment be assessed at 2 years in the prison. There's a $1,000 fine, and there are no applications. Is that correct?
Yes, Your Honor.
Any objection to the court changing the plea bargain paperwork to reflect that there are no applications?
No.
All right, did you understand that to be the plea?
Yes, Your Honor.
Defense, that's the plea?
Yes, Your Honor.
State, that's the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, I understand, Your Honor.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Yes, Your Honor, state I'll proceed to exhibit 1 and all attachments.
No objection.
All right, did you, state your name, excuse me. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. After reviewing the same, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just, I follow the plea agreement, Judge, and since the client to agree, 2 years.
2.
2 years.
All right, the court will sentence you to 2 years in the prison, credit for any time served. There's a $1,000 fine, time and money to write concurrently. I'm gonna request a therapeutic community for you. It's to help you with any type of drug addictions you may have. I do not have the authority to force them to place you in the program, but they'll see in the judgment that I'm requesting it for you, and you'll still need to request it. Do you understand? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record here someday. If you don't take care of this drug addiction you have, what's gonna end up happening is you're gonna end up in and out of prison. And if you become an enforced in. Okay. All right, good, let's just start. Thank you. Who else is ready? All right, have y'all conferred with Megan on that other matter?
Well, I spoke to her and Jason yesterday, and I believe Mr. Bunk did this morning.
All right, so I understand the issues. Do you have any issues with the reset? All right, so if y'all will confer with Ms. Ferguson on the reset, and please give me the cause number so I can put it in the system.
Oh, okay.
And anyone else ready?
Just waiting for the real Eric.
Oh, he's on Zoom.
Oh, he's on Zoom now?
Yeah,
Oh,
they,
we switched again. I didn't know, okay.
do you need to speak to him before you begin?
I don't think so. We're not gonna, no, this is just the token. I'm not gonna ask him any questions, so no.
Okay, and who's the prosecutor on this? Okay.
MTR.
So on each of these cause numbers, a bond has not been set, is that correct?
That is correct, Judge.
Okay.
On his two MTRs, I have a copy of one of them. So one of them is 2024 CR 1238. The other one's either 37 or 39. But motions to set bonds have been filed on both cases. And at this time, we're asking the court to set him a bond.
Okay, just give me a moment.
Yes, Judge.
All right, and are there going to be any witnesses?
No, Judge.
Okay. All right, in each cause number, the court, sorry, not in each cause number. Court is calling 2024 CR 1237 and 2024 CR 1238, State versus Eric Cantu. Can I have parties announced for the record for the state?
Lauren Espinoza for the state.
Charles Bunk for Mr. Cantu.
And are you Mr. Cantu? Could you unmute for me, please?
Yes.
All right, and are you Eric Cantu?
Yes, Your Honor.
All right, we're proceeding by Zoom with you, Mr. Cantu, because they brought to the court a different Eric Cantu instead of you. You have a right to have your case heard with your being present in court. So, do you have any objections to appearing by Zoom?
No, Your Honor.
Defense, do you have any objections to your client appearing by Zoom?
We do not.
State, do you have any objection to the defendant appearing by Zoom?
No, Your Honor.
All right, so Mr. Cantu, I'm gonna mute you on your end because we can hear other people talking. But if your attorney wishes to call you or testimony is needed from you, I'll unmute. And if at any time during the proceeding you have a question about something, just raise your hand and we'll be able to see. And if you make sure you watch that for
I'm
his
watching.
raising of his
Yes,
hand.
he's right on your left shoulder.
Okay. All right, so the defense has filed motions to set bond in each of these cause number. The charges in each of these cause numbers is evading arrest, detention with the vehicle. Defense, do you have any witnesses?
No, Judge.
All right, defense, you, and state, you have any witnesses?
No, Your Honor.
Are both parties proceeding on argument?
Yes, Judge.
All right, defense, you may proceed. It's your motion.
Thank you, Judge. At this time, we're asking the court simply to set a bond in Mr. Cantu's two MTR cases. He has been in continuous custody now since December 4th. I know the court is aware of the circumstances that led to that somewhat. And I'm not here to, at this time, contest or dispute those charges, but those are allegations on his MTR, which we understand. But on behalf of Mr. Cantu, we're requesting the court to set reasonable bonds.
All right, and what the court can tell both parties attached in the motion is the motions to revoke. So the court has reviewed that as a part of the motion to set bond. Mr. Cantu, the court does not take any allegations in the motion as true because the court has not heard any evidence in regards to that. But I do will take note of your previous conditions so that I may set an appropriate
Yes, yes,
bond
Judge.
if the court chooses to do so. All right, state.
Your Honor, I actually have the new offense report. Should you want to look at that, I can offer it as an exhibit.
Any objection?
Defense
No.
does not object. So at this point, state would move to admit or even marked as State's Exhibit B1.
All right, the court will accept into evidence States Exhibits B1 for the purpose of this hearing only, and will review the same.
mark it. One is fine.
All right, the court has reviewed State's Exhibit B1.
And if I could, Judge, at this time, I'll offer, this is a affidavit that is in the possession of the district attorney's office regarding that case, just so the court can also be aware of its.
All right, any objection to Defendant's Exhibit 1?
No, Judge.
All right, the court will review Defendant's Exhibit number 1, which is an affidavit from the complainant who is listed in State's Exhibits B1, and it's an affidavit requesting that there be no prosecution. All right, any other exhibits?
No, at this time, just argument, Judge.
Nothing else, Judge.
All right, if you all will give those to the court reporter, please.
Absolutely. You can go now. Thank you.
All right, so I'm assuming in each cause number that both parties will be asking for the same bond amount?
That is dope.
No, we're not at the same amount.
No, I mean, whatever amount you ask for will be
yeah.
the same in each cause.
Yeah, oh, yeah, I'm sorry, yes.
No, I'm sorry, it's me, because it'll
It's
make
late.
it easier
Right,
for the
no.
court
It
reporter.
would be much easier if your answer, first question was yes, but it's not, so. But
All
yes,
right.
it's the same in both cases.
All right, so defense is your motion.
Judge, at this time, we're asking you to set the bond at a maximum of $50,000 per case. We believe that is sufficient to guarantee Mr. Cantu's appearances in court, and the courts where he's never had an issue with appearing in court. With other conditions the court may deem appropriate, of course.
All right, so with regards to the request of the $50,000 bond, would you like to call your client to just answer questions of the bond amount he is able to make?
No, not at this time.
Okay.
Your Honor, state would be asking for a bond of $90,000 in each case. Although defense did proffer to the court the affidavit of non-prosecution we have received from the complainant, the DA's office has not made a charging decision regarding the new offense. Further, the issue is, in the state's opinion, is not that Mr. Cantu doesn't appear in court, but rather that he continues to victimize the community and pick up new offenses, allegedly, and that he cannot comport his behavior to that of community supervision, what has been ordered by the rules and regulations of that supervision. So we would ask for a bond no less than $90,000.
All right, if we could go off the record just briefly. Could I have parties approach? All right, Mr. Cantu, I'm going to ask you to unmute.
Yes.
All right, your attorney is going to call you with regards to a bond amount in your finances. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. State your name for the record. If you'll state your name for the record.
Oh, Eric Cantu.
All right, defense, you may proceed.
Mr. Cantu, how long have you been in jail, sir? Since the 4th of
For a
December?
month.
Okay.
Correct.
Now, your family and myself and you have discussed the motion we're here today to set the bond on your motions to revoke your probation, is that correct?
Yes, sir.
And you yourself, you don't have, do you have any bank accounts or money in the bank under your name?
As far as right now, no, sir, I do not.
Okay. Do you own any real property?
No, sir.
Okay, do you own a car that you own outright?
Actually, I did before, but now not anymore, no.
Okay, and am I correct in understanding that the bond, if you're able to make a bond, it's gonna be with the assistance of your family, is that correct?
Correct, yes, it
Okay.
is.
And your family and I have discussed various amounts, and is it your understanding that if the judge was to see fit to set the bond at $50,000 or less per case, that's
No problem.
an amount your family might
Yes,
be
sir.
able to raise given a little bit of time, is that correct?
Yes, sir, that would help a lot.
Okay, that's all I have, Judge.
Okay. All right, so defense is asking, for 50,000. Any other
Yes, sir.
argument?
Your Honor, additionally, I would just, as the court's aware that Mr. Bunk is retained, rather than court appointed, but that's.
Okay. Could I see, State's Exhibit again, please?
There's both of them, Judge.
All right, this is what the court is gonna do in each cause number. In each cause number, the court is gonna set your bond at $90,000. There should be full GPS. The court will ask that the GPS fees be waived. There should be no contact with the complainant. And that will be the court's order in each cause number. All right, so we can go off the record. And then with regards to the motions to revoke, do we have a contested hearing date for those or no?
Not that I'm aware of. We do? Oh, I'm sorry.
The normal setting, I believe, was on the 27th.
All right, we'll set it for a contested, and then if it's not going to be a contested hearing, then you all, we can change it, but just let probation know, so if there are any witnesses that they have, they can counsel.
So we'll keep our date for the 27th, but that will be for our contested date.
Yes, are
Okay.
will you be prepared on the
Yes.
27th?
Okay.
All right, so, Ms. Abrams, it'll be a contested hearing on the 27th. Is there anything else from either party?
Not at this time.
All right,
May we be excused?
yes.
Thank you.